Appeals Part-Head in the matter of Michael O'Hagan, FX Class Representative Limited and Evans and others.
Yes, Ms. Wakefield. Just before you start,
Yes.
or whoever starts, we did actually think yesterday that normally we have a break for the transcribers. We didn't actually do it. Nobody asked us to.
Sorry about
Do you
that.
want a sort of 5-minute ban? And I mean 5 minutes. I don't mean 5 minutes that becomes 10 or 15. But 5-minute break at 12:15 and 3:15 probably seems sensible. Okay. Right. Yes.
Thank you, my lord. So yesterday, Mr. Joel went through the strength of the claims test, strikeout test, and he spent some considerable time developing his own theory of harm. And there are some similarities between my case and Mr. Joel's case, but there are also some differences. Most importantly, I have two classes. So I have a Class A, which is made up of persons who entered into one or more FX spot transactions or FX outright forward transactions with a defendant during that defendant's cartel period, so a kind of direct harm in that sense. And I also have Class B, which is made up of persons who entered into those same sorts of transactions, but with a non-defendant or a defendant outside of the cartel period. So relevantly non-cartelists. We distinguish between those two classes of customers. We have different theories of harm, we have different data sets and different ways of quantifying the loss and testing for causation.
Yeah.
So it is necessary for me to go through that in some detail, but I'm mindful that I have 45 minutes in total before my 2 hours and 15 minutes is up, and I'll try and hit that deadline.
Is this just a sort of foretaste of the beauty parade tomorrow?
In a sense, but of course what I want to show your lordships is that we overcome the strikeout threshold very happily indeed.
One of the things that we think troubled CAT, and I think we were also not concerned about it, but we wanted help, is how you're going to prove the case in relation to the non-defendants in circumstances where, on the face of it, seems to us you're not going to get disclosure that really helps in relation to them. So any help you can give us on that, gratefully received.
I'm grateful, thank you, my lords. Just so you know where the key documents are from our perspective, we have the claim form, of course, which is in volume 1 of the key documents, tab 4. I'll be going there shortly. And then we have the following experts. We have Professor Rime, Professor of Finance at the BI Norwegian Business School in Oslo. Now, he is a world-leading expert in FX microstructure. Mr. Robertson tomorrow will take you through his various achievements and his authority, but you'll see his name in short everywhere if you read into this area. And of course, it's relied on in part in Sterling Lads. We have 3 reports from him, Rime 1, which went in with our CPO application. And as Mr. Joel said yesterday, in this particular structure, we have reports going in at the same time as the claim form, to which reference is made in the claim form. Rime 2, which is in volume 9 of the supplementals, tab 37, and then a Rime 3, which is in tab 49. We have Mr. John Ramirez, who is our expert economist, whose evidence I referred to yesterday in the context of practicability, your lordships will recall. And again, Mr. Robertson will develop this. He's given evidence of tremendous quality, we say. And again, we have 3 reports, as we do with Professor Rime. Ramirez 1, which went in with the CPO applications, Ramirez 2 in the first round of responsive reports, and then Ramirez 3 in the third round of responsive reports.
Yeah.
We also have a third expert, Mr. Richard Knight, who's an expert in FX markets and FX trading from the coalface, if you will. So he held a variety of roles in FX for the major banks over a 25-year period. Again, 3 reports, Knight 1, which went in with their application, Knight 2 in the first round of responses, and then Knight 3 in the third round. Coming back to pleadings or pleading style documents, we of course have the neutral statements to which Mr. Joel referred yesterday. And in case this wasn't quite brought out in the course of submissions yesterday, not only did everyone put in a neutral statement, or both applicants put them in, but there was then a process of annotation where we critiqued one another's neutral statements. So one has in the bundles various iterations of those documents. That was all before the hearing. Then following the hearing, after that...
And just to be clear for me, the mutual critiquing was between potential claimants, but not involving the defendant.
It involved the respondents as well. So the
And what status do those documents have, or are they just out there?
from our perspective, from the initial drafter of the document, they have a form similar, I would think, to voluntary particulars. There's further specification of our claim form. And then, in a sense, when one is critiquing the other theory of harm, on occasion one puts forward one's positive case, and again that further elucidates the issues in dispute, how things might ultimately be tried, and in a sense they may be seen as carried submissions in part. From the respondent side, I suppose they're essentially a response to the application for a CPO. So they're documents of a mixed status, but the tribunal directed that we produce those documents and that they go through those various different iterations. So it was a fairly laborious process, your Lordship will appreciate. I'm correct that we did actually 2 sets of neutral statements, one on the merits, so that's theory of harm, and one on funding, and the respondents only critiqued merits and not funding, so only one of the 2. So a pretty complicated process before the hearing, and then
Mr. Carey is agreeing with you.
And then after the hearing, we had the 2 rounds of documents which in the judgment are referred to as theory of harm pleadings. So those do have a pleading style status, voluntary particulars, further and better particulars. And we have the initial round on the 6th of August, and then we put in responsive further particulars on the 24th of September. So that whole mass of documents, pleadings, evidence was in front of the tribunal. If I might start with
When
my...
the tribunal uses the word pleadings, we view that as really the composite of all of these documents.
Absolutely, my lord. We say that's right.
Including the experts' reports.
We say that's right, absolutely. Though when we come to the paragraph in the judgment in which the tribunal assesses the state of the cases, it's notable that they seem to do so entirely by reference to, well, not even just less than the claim form, parts of the claim form, but certainly not by reference to any of the subsequent material. And I'll come to that in due course. So in the claim form, which is in Key Documents, Volume 1, Tab 4, paragraph 72, we have a description of our... Volume 1, yes, my lord.
Yeah.
Page 125.
Yeah.
So we have a description of the 2 classes, which I've just described to your lordships, and then over the page, explanation of the proposed classes. That's at the bottom of page 126.
Yeah. Reasons
for having those 2 classes. And we explain there, in para 75A, the different theories of harm. So we expand upon these later in the document. This isn't the sole exposition, but this is an overview. So in Roman 1, we have the direct effects of the infringements caused in relation to those specific transactions. Then in relation to Class B, we have 2 different ways in which they would have suffered harm. So first of all, we have a reduction of competitive pressure on the non-cartellist dealers by the cartellists charging the wider bid-ask spreads, which we posit in relation to Class A, which in turn allowed the non-cartellist dealers to raise their prices. So that's a sort of classic umbrella, if I can put it that way. And then in 2, we have adverse selection risk, which of course is where we find essentially common ground between...
That's the inter-dealer point.
That's the inter-dealer point, exactly. You have less information on the market, on the inter-dealer market, so you find you're suffering losses, so you widen your bid-ask spreads. So that's essentially the same as Mr. Joel's case. Then in little b, at the bottom of this page, and again at this stage it's just an overview of the 2 classes, an approach to calculating the harm caused to those 2 classes would differ. So we say we've got different data sources for the 2 classes. For Class A, as Mr. Joel said yesterday, we'll of course have the transaction data. Now Class B, Mr. Ramirez, endorsed by Professor Rhyme, had located these 4 different data sources. First of all, of course, proposed defendants.
I'm just trying to keep up.
Sorry,
Just,
my lord, I
just
don't interrupt you.
where's the reference to the sources of data for Class B? 2.
that's in
Page
2 at the top of
128.
page 128. I'm sorry, I'm going too
Roman
quickly.
2, Roman 1, Arabic 2. Harm suffered by members of Class B when counted as the conversation.
Absolutely. Absolutely, my lord.
So transaction data to measure.
So the proposed defendant's transaction data, that's from the periods when they weren't in the cartel, because the periods of engagement are patchy. Then we have data from the FX trading platforms, such as multi-bank platforms. So those are platforms on which are customer-facing, where the customers enter into trades with
So
dealers.
because this is something I'm interested in. These are, as it were, data source. A data source which would disclose not only what the cartelists would do,
Absolutely.
but the non-cartelists.
Absolutely.
So
Absolutely.
it's like
That's
a
the point.
Bloomberg screen or whatever.
It's exactly that. It's exactly that, yeah.
Yeah.
Quite.
We wondered whether that was.
Slow down, just take us through this document identified in particular the non-cartelist data sources.
Yes.
So it's the Bloomberg screens, as it were, is item 2. Sorry, item.
So I can
item
take
2.
I can take you to the relevant part of Mr. Ramirez's
But
report
just-
where he explains it. But just if I work through these 4 little Roman numerals within paragraph 2,
Yeah.
Lord Justice Green, do you have that paragraph?
I'm just trying to make sure I do. So we're
So
on page
128.
128, yes?
And so that is at the very top of the page. We have different data sources would be used to calculate, and then in 1,
Yep.
Class A, 2, Class B. So Roman 1 within that is the proposed defendant's transaction data, but for their non-cartel periods, because the banks weren't uniformly participating in the cartel. Then in 2, we have the data from the FX trading platforms, which are customer-facing platforms. So and I'm reminded of, by Mr. Robertson, of course, that in footnote 49, which is the footnote 2, Roman 2, we see it described, multi-bank platforms are platforms whereby a customer can trade with multiple FX dealers at the same time, and it's explained further in Mr. Knight's report, and Mr. Ramirez, in turn, has located samples from those sorts of multi-bank platforms, in particular one called SIBO, which we see in his report, data sample, and he thinks that he can use that to help him quantify the harm to Class B. Then we have data from CLS Bank International. Now that is a settlement platform, went into operation in 2002, settling transactions involving 7 currencies. I'm reading now from an extract from Ramirez 1, para 138. And settling transactions involving 7 currencies. By 2010, it settled roughly 43% of all spot transactions. Mr. Ramirez obtained a sample from CLS. In the sample he obtained, it contained only trades between dealers and customers, so again quite similar to the multi-bank platform information, but he thinks it possible that it would also have inter-dealer trades, because he doesn't really understand why it wouldn't, essentially, but in the sample he obtained, it didn't. And then finally, we have data from inter-dealer trading platforms, EBS and Reuters. Again, Mr. Ramirez obtained samples, and again he saw that he could see the deal by deal, transaction by transaction basis in those inter-dealer platforms. So he has all of those different data sources. Those are set out at considerable length, I have to say, in Ramirez 1, from page 607 onwards. And one sees samples throughout the document as well. So page 597 is where one sees the Reuters data sample. And if one were to wade into the neutral statements, then battle was joined between Mr. Joel and my
I was
camp.
just about to say, speaking for myself, it would be useful if there was some cross-reference, or I could be given 1 or 2 cross-references to critical documents which are going to feature in the argument tomorrow, for example, as I imagine they might.
Yeah.
Do you have any easily givable cross-references for some of these documents, at least the key 1 or 2? So that I could simply pre-read ahead of time, so I'm a bit off the curve.
So the principal document in which we set out our case is Ramirez 1, which went in with this document. But if your lordship would like to do pre-reading in advance of tomorrow, in my speaking note, I have neutral statement volume 13 of the big supplementals. I think that your lordships only have that in electronic form. Tab 66.
My tab.
Tab 66, page 3748. And it may be that this evening, or immediately after court, or even with a short adjournment, we can send your lordships further.
You don't have to do it now, and I'm not asking for a massive amount of
No,
stuff.
no, of course.
But it would be useful to at least have, you know, for example, a key document or documents that both claimants thinks is the best iteration of this point,
This point, quite.
you know, which you're going to now.
Yeah, I was just looking at what Professor Ramirez says, and we got that in behind tab 11 in the key documents bundle. You said page 607, and you're absolutely right, you can see there paragraph 137 as an example of the sample.
Absolutely.
That's the sort of raw data
That's the sort of, absolutely, my lord. And we see it over the page, 608, and then 609. One sees those samples, which Mr. Ramirez found. And in terms of battle being joined for tomorrow, page 3748 in the neutral statements, I'm sure there'll be similar iterations coming the other way.
Sorry.
This is the O'Higgins, in black, we see O'Higgins explain why it is.
Sorry, wait. Sorry. Go back.
Go back.
In the neutral statement.
We're in a neutral statement here. If we go to page 3725 of the neutral statement,
That's not in the key documents.
it's not in the
It's
key document, it's
in the
electronic.
bundle.
So your lordships may need to look at that separately. I'm sorry about that. We did our best to pick the key documents out, but you'll have it there.
But it would be useful to see identified if we're going to be asked. If we're going to be asked, for example, to go to some of this stuff tomorrow, and I don't know what course the debate will take, but if we are going to be asked to go to it, I do think it would be useful, certainly for me, I speak entirely for myself, at least to have had a chance to flick through the document ahead of time, so I've got some familiarity with it. So
Competitive pre-judicial reading, we of course will do exactly the same, won't we?
I've been told that hard copies can be available this afternoon. Sorry, Mr. John.
Maybe we could allocate it.
My lord, I'm conscious that, I mean, it's important that in a sense that you see both sides of this, because this was a debate that went across a number of expert reports with both sides pointing to these sort of third-party Reuters type screens that could be used, and saying which were appropriate and which were not appropriate, and you see it in Breeden and Bernheim as well. So we could try to give you if you're interested in going down this particular rabbit hole, we need to make sure that we
the critical
do
issue
it fairly.
because we can't go into this in any great detail for obvious reasons. But I mean, is it challenged on your part that these four sources of data are potential sources of data for what we were asking you about yesterday, which is how you're going to prove the case?
So the short answer to that is to read the supplemental bundle, tab 50 from third supplemental bundle, tab 50 from paragraph 5.7 to 5.14, where Professor Breeden goes through all of these different data sources and gives his views on them. And the answer is he proposes to use some for some purposes, and others he says are not
That doesn't surprise me.
You describe it as a rabbit hole, and I'm certainly not willing,
Yes.
I don't want to be heading down one. If both of you think that this isn't the way that the debate is likely to go at any point tomorrow, then obviously we don't need to look at it. But if at least one of you is going to be suggesting this is something that we need to look at, all I'm saying without any prejudgment is I wouldn't mind doing a bit of pre-reading.
No, indeed, and I totally understand it. From our part, it was not how I intended to approach carriage, because this is not an issue on which the tribunal, at least, decided carriage. As far as I can discern it now.
Both of you have to say that there is a sufficiently robust corpus of data which will enable experts
Absolutely,
to deduce the umbrella effect.
that's right.
and you may disagree as to what they are, some may
Yes.
be more effective than others, more reliable than others, but a basket of data, you both say, is available.
That's right.
Yeah.
And the rest is nuance, really. It may be that they wish to make something more of it.
Now matters are going to get complicated.
Now hopefully I'm going to clarify for Mr. Joel, we do take issue with their approach to interpreting the tribunal's judgment. We do think, and we are going to be submitting tomorrow, that this aspect of identifying the loss by trading with non-defendants was at the heart of why the tribunal distinguished between the Evans and O'Higgins applications. So I am going to be going to the sources of data that Ms. Wakefield is currently outlining, and I'll be taking you through to the expert reports.
You both have to remember that the exercise that we're concerned with, whether it's appeal or judicial review, is going to be limited.
Yes, I'm intending to elucidate the tribunal's judgment, which distinguished between Evans and O'Higgins.
This is the only part of the judgment you therefore say is right.
There are other parts.
Well,
Better thought
it's
through,
a-
I think, is how it was put.
Better thought through,
In a
more
rather
suitable.
oblique way. It doesn't really spell out how they thought it was better thought through. But
There's no clue in the judgment at all about that. This is just complete
well, then you get your say tomorrow.
interpolation. But if this argument is going to be raised, then if I may, it is important that the tribunal does have, that this court does have a full picture of the argument on both sides. What I would suggest, if I may, is that we try to agree between us just a list of the evidence on point, so that if the court is interested, then
In the beauty parade, you give us a little chance to pre-read your most attractive document.
exactly. Sorry, George.
I'm grateful. So I was on page 128 of key documents in my claim form. And we just worked through those various data sources. I won't say anything else about them for today's purposes. And then in Roman 2, halfway down the page, between the two hole punches, Mr. Ramirez intends to use multiple regression analysis to calculate the harm. And he'll run separate analyses. So one analysis for Class A, and then different analyses for Class B. And in fact, he proposes to run different regression analyses for those different data sources. And as is explained at the end of the last sentence on that page, the overcharge calculated as a result of those analyses will be combined into a weighted average overcharge for Class B. Jumping forward through the claim form to paragraph 156, which is on page 162. Again, we have reference to proposed methodology. Again, we see Mr. Ramirez referring to regression analysis, again referring back to Professor Rhimes' report. And I'm not going to take you to Ramirez 1 today. I'm already quite short of time. But were you to turn that up, tab 11 of the Key Docs bundle at page 594, you'll see his detailed current attempts to identify the explanatory variables which you need to factor in to those regression analyses. They broadly fall into three categories: operating costs, inventory risk, and customer-specific factors. You can work through those pages, see the granularity of his attempts to do what is, in essence, a causation exercise. Because obviously one has to identify those variables accurately.
So what was the page reference
That's page 594
of the key documents?
of the key documents.
In Professor
Hard
Ramirez,
copy.
in Professor Ramirez's report,
Exactly so.
which I don't have.
You do for that, my lord.
My document stops at 588 and
Oh,
starts 589.
I'm sorry.
and
I'm sorry then. We'll make
starts
sure.
at 604.
We'll make sure you have that. I'm sorry. We do have a very long version of the supplemental bundle, but obviously only in electronic form. So we'll make sure that
Obviously
you do
only
have that.
included the stuff that was thought to be key.
Absolutely.
Okay.
It does jump.
It does. It does. I'm sorry about that. So we'll make sure you have that for tomorrow as well. But of course, the accurate identification of
I was just claiming responsibility because I think I ordered that a reduced bundle be produced.
I didn't want to say that, my lord, but you did.
Well,
The
at
choice
least
was
we're
up to you.
relieved from literally an entire carousel full of bundles, only 1.5 of which we ever look at.
That's true, that's true. We now know what you do need to look at. We can produce that
The story
tonight.
of my life as a judge, really.
Yeah, I'm sure. So you'll see in due course the care with which he already has approached that exercise and with which he anticipates approaching that exercise. Para 164, over the page, again, available data. We see again these different data sources set out, again in some detail. And then turning forward to paragraph 247, which is on page 207, we hit the causation part of what might be called the conventional pleading. A lot of what's come before now, I should say, relates to the specific needs of the collective proceedings process. So now we hit what might be there in a more conventional private law claim. And we see paragraph 249, particulars of causation. Now, I will shortly, and I am very short of time now, but I will shortly turn to the August submissions, which pull together all the subsequent documents which were filed in this regard. But just starting with 249, this relates to the harm that was caused to members of Class A who entered into those direct transactions. And in particular, the second sentence of 249 refers to section 5 of the Rime report. You do have that in your key documents bundle, that's tab 10, page 449 onwards. And it explains how the exchange of that current and forward-looking commercially sensitive information on bid-ask spreads applicable to certain currency pairs for certain trade sizes facilitated explicit. Now, we clarified subsequently that at the moment we're focusing only on tacit until we have the content of the chats. We think they may have caused explicit coordination. We don't have a methodology at present. And or tacit coordination on the bid-ask spreads charged to members of Class A. And we explained that that would have widened the spreads. Jumping over 250 and 251, we have in paragraph 252 the theories of harm in relation to the loss to Class B.
Yeah.
I've already explained those two different theories. We see them in little a, two ways. Classic umbrella, lessening of competitive constraints, and then in B, adverse selection. Exactly, and its consequences. Now, if I just quickly turn up the August submissions so that you're familiar with them, I won't have time to go through them in any detail, but they are in Key Documents, Volume 3, tab 75.
Yeah.
So if we start at page 4938, paragraph 26, direct harm. Paragraphs 28 to 32 on the importance of bid-ask spreads and the exchanges of information in relation to them. Of course, that's supported by Sterling Lads. Paragraphs 33 to 34, we see the immediate impact of each instance of a bid-ask spread exchange on the transaction which is being discussed or for the immediate period which follows. And then under the heading, cumulative impact of bid-ask spread exchanges above paragraph 35, refers here to section 5.1.2.2 of Professor Rime's report, which were I to have more time, I would turn up. But essentially, in that part of his report, Professor Rime explains how spreads quoted to customers usually fluctuate around a baseline, remaining relatively constant over time. And so even relatively infrequent information exchanges enables traders to have a very good insight into the baseline spreads of their competitors. So that's the long-term informational advantage one has through participation in the chat room. One understands the baseline spreads of the banks who would otherwise be competitors. Tacit coordination has well-known three component parts to it. Sufficient market power, degree of transparency, and a degree of deterrence. Now, these are addressed in detail in these submissions, this further and better particulars. And we see that in paragraphs 37, 38, 37 in particular, I should say, relates to, in a sense, a prior question, which is probably something which Mr. Kennelly will come to today, which is how is it that the conduct of certain traders in the chat room could be taken to have influenced the conduct of other traders in their bank? So we're still within the cartellist bank, but traders who weren't in the chat room. And we deal with it here by reference to the senior roles of the traders, the culture of the trading desk. And one sees as well, if one turns up, the evidence of Mr. Knight, the trader, and Professor Rhyme, quite how information is disseminated within a single trading desk, essentially, and one can see that on the evidence. Then the first condition, sufficient degree of market power, we address at paragraph 39 of those post-hearing pleadings. That's on page 4942. We have the combined market share of the proposed defendants, with the next largest share being Deutsche Bank, and otherwise all the FX dealers having much smaller market shares. We also have the uncompetitive nature of the market more broadly, not least because of ASR, and reducing the perfectness or imperfectness of competition on the market, and a conclusion that they do have sufficient market.
Just one.
I'm so sorry, I'm going so quickly.
ASR?
Adverse selection risk.
Sorry.
So that's the theory of harm, which is
Yeah,
common ground between us.
Sorry.
I'm sorry.
Sorry, that's the first time that
No.
abbreviation has been used. I just didn't pick it up.
No, I
Sorry.
apologise.
Okay.
And of course I could, were I to have well enough in time, go to each of these underlying documents. I can't do that. I don't have enough time to do it.
No.
Sufficient transparency we have in the second condition. We have the bid-ask spreads themselves, helping the traders to monitor one another's conduct. We have the degree of switching in the market. Now, this was something of a vexed question at the hearing before the tribunal. Is there switching? Is there not switching? And the answer is there is some switching, but not much switching. And we get to that in this document at para 44. And also in a similar vein, paragraph 77, elasticity of demand in the market. So there is a degree of customer adherence to their banks. That's why you can raise your prices and not immediately lose all your customers. But there is a degree to which customers do shop around and look for other prices. That's the way in which umbrella harm eventuates. So it's not black and white.
Is switching affected by the extent of the umbrella effect, so that the greater the umbrella effect, the less
you switch.
elastic the market is?
Absolutely.
That
There's
might
nowhere
be,
else to go.
There's nowhere else to go, absolutely.
I mean, that might be an indication of the umbrella effect. If you see minimal elasticity,
Quite,
it might suggest that there is nowhere else to go because of the umbrella effect.
quite, absolutely. Absolutely.
Yeah.
Jumping back to para 41, which is retaliation mechanism and deterrence. And there are findings in the decision that there was monitoring of compliance and traders apologising when they didn't adhere to the understanding. Those recitals in the decision are set out in the second report of Professor Rhyme. As to the widening of spreads in general, in a sense we've just touched on it in the exchange between myself and my Lord Justice Green. It's said by the respondents, well, why on earth would anyone widen their spreads in this context? You have our economic arguments why, you know how we're going to test for that, but of course it's supported by Sterling Lads as well now, because that exact same argument was run by Credit Suisse and was rejected. And we also know, of course, that we could end up via disclosure having more documents which may support that, not least measure of profit, bonuses, for example, which are referred to in Credit Suisse. So that's direct harm, Class A direct harm. Class B, you have umbrella effect, which we address in paragraphs. So Class B starts at paragraph 47 on page 4947. less competitive market conditions is at paragraph 51. And we set out the part of the Advocate General's opinion of Advocate General Cocotte, this is at paragraph 53, in Coney, in which, of course, the Advocate General expresses her view that this sort of umbrella effect is, well, we know following Coney that it has to be available as a matter of national law, but also she sets out that this can happen in markets with comparatively little transparency and so on. But there we are. That's the law on it. It has to be available. And we say it's not novel or surprising or difficult. Then increased adverse selection risk in paragraphs 54 onwards. Mr. Joel has largely dealt with this. I will gratefully adopt his submissions. There are some differences between us, but not many. We have a series of paragraphs in these pleadings with underlined first statements. One could read through all of them, but they address various queries that were raised at the hearing and which we thought we'd addressed in these submissions. And again, of course, we know that adverse selection risk is really at the fore of a lot of the findings in Sterling Lads. We also know that it's not theoretical, and if I could just turn up one document in Key Docs 1. This is Professor Ryan's report, page 490.
For
490. Oh, I apologise, it's not in
Again, we
here.
haven't got that.
Sorry, we'll have to provide that separately.
Okay.
The short point is that he refers to various studies of exactly this conduct. So informational asymmetry on the interdealer market, and the spreads go wide. And he refers to 3 academic papers in particular. My learned junior, Miss Bird, has read the papers, and 2 of them are based on data, on hard data, and on regression analysis, and on looking at instances of informational asymmetry and what happens the bid spreads go wide. And so I wanted to take your lordships to that, because I know one of your queries yesterday had been, how grounded is this in empirical evidence? And I say, as Mr. Joel said yesterday, the academic work is entirely grounded in empirical evidence. That's its very nature, that's what it does. So I turn to the judgment, if I may, against that backdrop. I prepared on Monday this week and provided to Mr. Kennelly in advance a document very similar to the document which Mr. Joel prepared in relation to ASR, in relation to the parts of the theories of harm which only I am running.
Yeah.
And if I might hand those up.
Two of the same. If there's different ones.
I'm sorry, there's a whole bundle of them that's been handed up, but you only need one each.
We've got 6 documents.
Well, you should only have 3, I'm sorry about that.
Okay, so they're all the
They're
same.
the same, they're all the same.
Okay.
That's my fault. That's my fault, sorry.
One of those two. Okay. Thank you. No, not your fault at all.
Sorry about that. So, Mr. Joel took you to paragraph 238 of the judgment.
Yeah.
And it said that the criticisms in 238 can be read across to my claim, and I rely on his rebuttals, even though there are some small differences between us. 239 relates to me and me only. And if we go onto the second page of this document, in the left-hand column, we have the language of the judgment set out in inverted commas. And you'll see, your lordships can read it in slower time to yourselves, but you'll see in short that the tribunal professes to be not to understand at all how it's said that harm could eventuate to Class A. It doesn't understand, it says, how exchanges in relation to particular trades are said to impact more broadly. We explain in the right-hand column that we have pleaded exactly that. That Professor Rhimes' report, which you'll recall was referred to in paragraph 249 of our claim form, explains in terms this changing of the baseline spreads causal mechanism, and that's expanded on in detail, as I've just shown you, in the August submissions, also I think in the September submissions. That's what they say about Class A. They say we just don't understand it. And in fact, in a footnote, I'm not going to take you to it given the time, but in a footnote they say, well, there's a bare averment, and they just cite a sentence. That's the first sentence of paragraph 249, and it misses out the second sentence. The second sentence is the one in which we explain the causal mechanism and refer to Professor Rhyme. So it's just very strange and frankly a little unfair, really. We then go to 239 sub 2 Roman 1, where the tribunal is addressing Class B. That's all they have to say on Class A. We go to Class B. But for Class B, in fact, a lot of what they're saying relates to the plausibility of the Class A harm, because they're thinking just about this less competitive conditions argument. And so they circle back to querying how it could be that the spreads would widen. They raise questions of the way the market works, the concentration, elasticity, market power, all of these points, and say we haven't answered them. And you'll see in our answers in the right-hand column, and I've taken you to them in any event, we have pleaded those points, we have answered them. Our case on them is really clear, and so too is how we intend to make that case good. Over the page 239 to Roman 2, again, they say it's in our case on widening is insufficiently justified. Again, we say that's just not true. And we see in the column on the right-hand side, we have that reference as well to Sterling about supporting our position. A similar point in Roman 3, it's unclear how one ever would widen the bid-ask spreads. Again, we say we've explained that several times. Then little 3, they say, oh, well, it is the case that in the August pleading, Evans attempted to begin a pleading on elasticity. Well, in paragraph 77 at the end of that document, there is a straightforward pleading on elasticity. Professor Rhyme also gave evidence on elasticity at the teach-in. We explained elasticity at the hearing. Plainly, that's enough for strikeout. Plainly, it's enough for strength of the claim, whatever strength of the claim means. Plainly, frankly, it's enough to get you towards trial and to begin talking about the sort of disclosure orders should be made and general CMC business. That's where we say we are. And then 2394, this is the true first theory of harm for Class B. And it said, just as the claim is also unexplained by the Evans PCR, and the constraints arising out of intra-market competition is not addressed. Again, that's not right when you look at the Rhyme report and at those submissions we put in August, the voluntary particulars, those pleadings which set out exactly what our case was on questions such as switching, intra-market competition. That's what we were addressing there.
Can you just unpick paragraph 2393 for me, or how you say it should be read, or how you respond to it, because I do have some slight difficulty understanding exactly what the CAT was doing in 2393.
I don't understand it either. Right. So obviously they were interested in switching, they were interested in elasticity of demand. They'd asked us those questions in the hearing, we'd addressed them in the neutral statements, we'd addressed them in the teach-in, and we addressed them again in our August document. It may be that they thought they needed to deal with paragraph 77 of our August document, and so acknowledged it in this way.
I mean, what they seem to be saying is that it's troubling that a significant point should have gone unstated for so long. But they then, at footnote 154, suggest that the point is pleaded in the theory of harm pleading. So, in other words, by the time they gave their judgment, the point had been pleaded, they appear to have acknowledged. Better late than never, they say, but it's there. Then they say we do not intend this as a criticism, but merely as an indication that it is possible to make assertions in pleadings about the operation of markets.
Yeah.
So in other words, I read that as saying, you know, better late than never, but we're not criticising you. But it's there.
Yeah.
And then we are satisfied the difficulties we are identified remain. What does that mean?
I don't know what the last sentence means. I don't know what difficulties they're referring to then, because the whole rest of the paragraph relates essentially to this intra-market competition point. How could you raise spreads, widen spreads, because you'd have lost business. So I don't understand the last sentence at all. The penultimate sentence, I think, may go to some of the submissions which Mr. Joel and I were making in the course of the hearing, and which he averted to yesterday, namely that you don't need to plead market characteristics, that those don't form part of the essential facts, or not, they wouldn't normally form part of the essential facts, certainly when alleging a fairly conventional theory of harm like umbrella pricing. And so that was perhaps referring back to that dispute, because of course the tribunal's view is one should plead all relevant qualities of the market. But of course, as your lordships noted, we had, by this stage, we'd taken our medicine, we'd done what we'd been told to do. One can be under no doubt as to what we say about the concentration levels of the market or the atomised nature of the market, switching, elasticity, everything else we'd set out. And yet they still struck us
Do they mean
out.
that the difficulties that they identified in their letter of the 21st of July 2021 remain? Anyway, you say you don't.
I don't know.
Maybe for Mr. Kennelly to tell me what it means, but I just don't really understand what the paragraph
No,
is
I don't
trying to say.
understand it either. And it obviously is like, well, this doesn't matter one way or the other legally, but it's slightly dispiriting to have tried so hard to answer the thing we were being asked to do and be told that, well, we did it, but it still doesn't really count. But there we are.
Yeah.
I have slightly gone over my time anyway, so I'll deal with the rest of my points very quickly. We're turning now just to the grounds of appeal, and obviously I have grounds 3 and 6, so I separate out challenge to strike out and challenge to strengthen the claim, but I entirely accept, of course, that the way in which strikeout is given teeth is by the reliance on the strikeout findings, the finding that this is a claim which should be struck out as part of the strength of the claims assessment. So in that sense, the two of them come together. And I'm entirely happy to adopt the submissions of Mr. Joel on strikeout, on the right standards for pleading, and I say that plainly this mass of pleading material surpasses the requirements at this stage in any proceedings. In terms of the strength of the claims factor, there's probably little I can add usefully to that which was explored yesterday with Mr. Joel. I do say that this is a criterion which, although we see it on the face of the rules, it's difficult to give it any significant weight. And I do agree with Mr. Joel that in accordance with paragraph 108 of your Lordship's judgment in La Patorelle, there obviously is no additional merits threshold that has to be met before proceedings can go forward on an opt-out basis. That's plainly correct in the light of the Supreme Court's judgment in Merrick's. It's also, of course, right that leaves very little, if any, analytical space for strength of the claims to operate in. So that is a difficulty, and it may well be that in most cases...
Well, in a case in which there's been a strikeout application,
Of
yes.
course, now of course...
But not in a case where there hasn't.
Not in-
Because in
not-
a case where there hasn't, you simply ask the question, well, is there a real prospect of success? And,
Yes.
and the point we were making in paragraph 108 is you don't go beyond,
And you
there isn't
don't
some higher
There's
threshold.
no higher threshold, exactly. So the tribunal in this case was wrong to fashion some kind of plausibility plus threshold. That's entirely wrong. So we say, whatever it means...
It's slightly different. I think we were keen in Le Petrol not, never say never is a very good motive to follow. We could see that if you could have a case, as I referred to yesterday, a very strong effects-based case which did 95% of the work, And that might just make it very easy for the cat to run the trial. And it could make it easier for an opt-in, I suppose, depending on numbers, depending on size of claim and so on and so forth. So we could see, at least in theory, there could be some cases. We highlighted a case which was very strong, which might have implications. So we may not want to go as far as saying that it never does, but it's no additional threshold. Once you've met the good case threshold, it's hard to see how the merits are anything other than neutral in the vast majority of cases thereafter.
Your Lordship took the words straight out of my mouth. I was going to make exactly that submission, that they're normally neutral. And in fact, where the case is particularly strong, it's not obvious that that would always point in favour of opt-out. And it could
go either way.
It could go either way, absolutely, absolutely. So those are my submissions on strength of the claim. I do have an additional ground 5. I'm not proposing to spend any time on that. You have my submissions. Those relate just to 3 additional errors. 1, the absence of a pre-existing body, which it was said also weighed against us, the fact that we weren't a pre-existing body, and that apparently made it more likely that it should be opt-in, not opt-out. We say that's wrong, and we endorse the reasons of Mr. Lomas in paragraph 41513 of his dissenting judgment. You'll see that in my skeleton argument. Level of funding, it was said that because we lack a sufficiently large fighting fund, again, that speaks in favour of opt-in. Again, we say that's wrong because, if anything, it's the very opposite, opt-out proceedings being, in general, easier to fund and cheaper to run. Again, we endorse the reasons of Mr. Lomas in that connection. That's para 415 sub 16. And Allianz, again, that it was said that spoke against our going forward on an opt-out basis. We say the opposite, and again, we endorse Mr. Lomas, who says, well, it shows that those who may have opted in have already gone, so you've lost the only ones who might have joined in the first place. And that's 415 sub 19. So unless I can be of any further assistance, having overshot slightly, that's everything I wanted to say.
Thank you very much indeed, Ms. Wakefield.
Thank you.
Please, Your Lordships, I'm going to take the 2 points of statutory construction first, so that we can properly situate the other issues in the legal framework. And that is the jurisdiction point raised by Mr. Evans' first ground, and the proper construction of the strength factor in Rule 79.3a.
Do we need to hear? It's not jurisdiction. No, we don't need to hear your jurisdiction.
I'm grateful. I will begin then, in order to properly understand the role of the strength factor and to address some of the points raised by my Lord Justice Green, with some pre-legislative material, and then I'll turn to the rule itself and the judgment. And I'm going to show you some of the legislative material. Some of this was before the Supreme Court in Merrick's. It goes to show the mischief which the rule and the opt-out, opt-in choice was designed to address. And if I ask you to turn up, please, first to the Authorities Bundle 5, tab 52.
Is this Merrick?
No, this is I'm going to the pre-legislative material. I was just simply explaining why I was going.
Oh, yeah, I've got you. Yeah, the consultation.
Indeed. And so I'm beginning with the Civil Justice Council recommendations to the Lord Chancellor. And if you go, that's in tab 52, in the 5th volume of authorities. It begins with page 1570. And go please to page 1574, just for the heading. Recommendation 3. Collective claims may be brought on an opt-in or opt-out basis, subject to court certification. And then go please to page 1576. 1576, the second paragraph between the first and second hole punch. The approach is one, this approach of offering opt-in and opt-out as a choice, is one that does not therefore recommend the introduction of any form of presumption as to whether a collective action should operate on an opt-in or opt-out basis. It is an approach which places the responsibility for designation with the court at the certification stage. It's notable that in all the opt-out regimes in North America, they include within their certification criteria a requirement that the opt-out action be judicially compared with other available procedures, a superiority criterion. Hence, a discretion on the part of the court to refuse the opt-out action from going forth is already built into a sophisticated opt-out model. Most importantly, it's been a subject of close analysis and developed jurisprudence. Hence, it's not the case anywhere in the world that an opt-out model is invoked with no consideration of other procedural mechanisms and how well suited those other mechanisms are to resolution of the dispute. Over the page 1577, very bottom, it begins first, very second hole punch. An opt-out collective action aims to create effective access to justice, and I'll come back to this important concept, for citizens who would not otherwise have any or any effective access to justice. This is particularly the case where small individual claims are concerned, or where litigants who are denied effective access to justice through reasons of individual impecuniosity are concerned. And then we have the government's response to the consultation preceding the bill in January 2013. And this was actually relied on by Mr. Evans in the pleadings before the tribunal. It's behind tab 53. Tab 53 in the same authorities bundle 5. You see the first page at 1580. Go please to page 1591.
Just out of interest on that previous one, 1578.
Yes.
1578. The Article 6.1 rights that were in play there are the rights of defendants.
Yes. So now we're on tab 53, fifth authorities bundle.
Yep.
Page 1591. And we see the government's decision. Paragraph 511 first.
This was the document we've just seen was the CJJ report. It
Yes,
wasn't the
indeed.
consultation paper, was it?
No.
CJC.
It was the
CJC, yeah.
exactly CJC recommendation.
This is the
government response to the CP, the consultation.
Indeed. I'm not taking you to everything.
No, no.
This is, as you say, the government's decision. 511, the government recognises the views that were expressed in the consultation, the concern of respondents who worry about frivolous cases, who don't want a litigation culture. Equally though, 512, it's very clear the current system of collective redress does not work. Consumers are not currently getting redress for breaches of competition law. It goes on to describe how tinkering isn't going to be good enough. And it says at the very bottom of 512, it's also clear there are some cases that could only ever be brought on an opt-out basis in practice. Then this at 513, the government does, however, firmly agree that strong safeguards would be needed as part of an opt-out regime. The design details will therefore be critical, and a range of safeguards, including certification and so forth, will be introduced. And then at 514, the government has decided to introduce a limited opt-out collective actions regime with safeguards for competition law in the tribunal. In 515, and by the way, that reference to strong safeguards was quoted by Lord Sales and Lord Legate in Merrick's. In 515, the government does recognise that there may be some collective actions which would be more appropriately brought on an opt-in basis, such as, and this is just an example, those brought by a small number of businesses, all of whom are clearly identifiable. Therefore, decided that the tribunal will be required to certify whether a collective action is brought in the new regime is suitable for collective action and whether it should proceed under an opt-in or opt-out basis. I'm referring to these because they're relevant not only for the point which I've been told not to address, but also for the submissions which Mr. Joel made in relation to the strength factor. So the tribunal's jurisdiction is stressed here, and the choice is given to it in relation to opt-in and opt-out. It's a matter for the tribunal. But then this 518, regarding whether collective action should be available to both consumers and businesses, the government recognises in some case businesses will be well placed to take action themselves without the need for collective action. The government therefore believes that collective action should only be certified if that is the best way of bringing a case. And then at 519, there's a discussion about whether small businesses could be carved out. Small businesses often have difficulty in bringing cases themselves. We see at the bottom of 519. The government considered at 520 whether or not different provisions should be made for SMEs and larger businesses. But it listened to the respondents and found that in practice it was difficult over the page to distinguish between large and small businesses in terms of access to court procedures. So they didn't make a distinction. They didn't make a distinction that would limit collective actions to small businesses, although consumers and small businesses were the target of the reform. Then we turn, please, to the government statement which accompanied the bill. That's behind tab 55. On the same bundle, page 1610. And I'd ask you to go, please, to page 1612. And you see a reference to page 1612, very short passage at the first hole punch. Under the bill, they would have to opt out if they didn't want to be included in the action, class members, in order to prevent US-style class actions. There will be a range of safeguards, including certification as to whether it should be opt-in or opt-out, stressing again the importance of the safeguard. And I'd ask you to go next to the 6th volume of authorities and the government's response to the consultation, this time on the tribunal rules. That was on the Act, now returning to the tribunal rules. 6th volume of authorities, tab 57. Begins at page 1651. And then we have page 1653, the criteria for certifying claims. And I should say, my lords, all of this material is obviously before the tribunal. We debated it at length before the tribunal. Middle of page 1653, summary of government decision to include draft rule 78.3a, the strength of the claims as part of the certification criteria for opt-out collective proceedings. And we have over the page, top of page 1654, the government has introduced a number of safeguards. These include no treble damages, no contingency fees, and the CAT will certify whether a claim is suitable for collective action and whether it should proceed under opt-in or opt-out. And then the government response, 316. The government believes that the strength of the claims criteria is particularly important for opt-out proceedings, as cases can be brought without class members' knowledge or consent, as they don't need to actively participate in the claim. Now, you saw an echo of that in the passages of the judgment, the buy-in issue, which was criticised by my friends, but it's there in the government decision on the rules, as they don't have to actually participate in the claim. As a result, we have decided to incorporate this into the rules. This will not, however, amount to a full merits test. So there is a merits analysis, but it's not a full merits test, and the approach of the tribunal will be clarified in the tribunal's guide. And now, turn, if I may now, to the strength factor, and the particular arguments made by Mr. Joel which I think form part of the third and sixth of the Evans grounds of appeals and the first of the O'Higgins ground. And for this, I'd ask you to turn up the rules, which are in the first authority manual, tab 5, page 52. And just to state the obvious, Rule 79.3, to look at it again, provides expressly that in determining whether a collective proceeding should be opt-in or opt-out, the tribunal may take into account the strength of the claims. It's only one possible factor among many. It isn't given preeminence. The Parliament has seen fit to make it express. And Mr. Joel argued that properly construed, this means, because the word strength was used, this means that the tribunal may only take this factor into account if the claim is strong. The tribunal, he submitted, is prohibited from taking into account the weakness of the claim in deciding whether to order opt-in or opt-out. Now that is a very strange construction, because presumably the tribunal would have to undertake some kind of merits assessment to some extent, even to establish that the claim is strong. But my friends seem to be suggesting that if the tribunal does that exercise and finds that the claim is very weak, it is prohibited from taking that into account.
It seemed to me, speaking for myself, that submission ran contrary to the decision of this court in the Patrorel. I mean, there may not be there isn't an additional threshold, but there's still a threshold, and that threshold involves an assessment of whether the claim is sufficiently strong that there's a real prospect of success, or sufficiently weak that there's no real prospect of success. The one must follow from the other, and the idea you only look at one side of the picture just seems to me to be curious, shall we say.
At the very least, not least because it would be a major limit on the tribunal's own discretion. Yeah. This rule stresses how wide that discretion is. The tribunal may take into account all matters it thinks fit. But according to Mr. Joel, Rule 793 can only operate one way, where the claim is strong to assist the PCR, but never when the claim is weak to assist the respondents. When pressed by my Lord Justice Snowden for support for this construction, he gave two reasons the court will recall. The first, he said, was the use of the word strength. He said that term meant the tribunal may only apply this factor for strong claims and not weak ones. Yeah. But that, as my Lord the Chancellor said, doesn't make sense even as a matter of language. In assessing the strength of something, one has to ask how strong. It could be not very strong at all, quite strong, very strong. That covers extreme weakness and extreme strength. But secondly, most surprising of all, Learned Friend invoked as a second reason, fairness. He said it would be unfair on applicants to have their claims judged as weak at the certification stage. It would be unfair, he said, to prejudice the claims in that way. But what about the respondents? On Mr. Joel's construction, there is no unfairness in having their prospects found to be poor in a certification judgment. But it would be unfair to do that to the PCR.
Can you give us an example of a situation where you may have a very weak case, and how it would be relevant to opt out or opt in? I'm just trying to think one through. I mean, you might have a case where there's no commission decision, so it's not followed on. There's no strikeout application, where the pleading is desultory and speculative, and as the minority said in Merrick's, there is a real concern that the only reason the funders are involved is because they want a battering ram to achieve a quick and dirty settlement. The tribunal may say, well, in those circumstances, it's opt-in because there's nothing really to take forward. I mean, I can see perhaps that might be the sort of case. I'd have thought those would be extremely rare.
So that was a question, my Lord, that you asked earlier. Why is strength there at all in making this decision between opt-in and opt-out? And in our submission, it is part, as we saw in the pre-legislative materials, part of the safeguards established in view of the risks involved in opt-out. It has a protective function to protect respondents from weak and oppressive opt-out proceedings. it's plain as day that, and it was made, the point was made by my friends, that opt-out proceedings are inevitably larger in terms of claim value than opt-in proceedings. From a defendant's perspective, they can operate more oppressively for that reason. The claim values in this case range from £800 million to £3.2 billion. The Parliament had that in mind, and that is why, to strike the balance that we saw in the pre-legislative materials, they introduced this factor for a protective role. It may also have a role described by Lord Justice Green, where in order to vindicate class members' rights, it would operate better as an opt-in case. One could also imagine a situation where disclosure might be more easily obtained from the class members in an opt-in case, and therefore opt-in would be better for them as class members. But I don't shy away from the protective function of the strength factor. That's why we say it's part of the balance that Parliament.
Because people say the minority and the majority merits are inconsistent. I mean, the minority took a fairly strong position explaining the risk of leverage, but the minority also said that one of the reasons why you have the cat's gatekeeper role is to ensure that there is a proper protection of defendants. There's not that much between the majority and the minority.
And that's the point I'll come to. The majority didn't say that the minority was wrong when it identified the risks of oppression. It just ultimately didn't change the majority's view as the proper approach to certification.
Yeah.
But the risk certainly was there and doesn't seem to be in doubt as between the members of the court.
I mean, the response document that you showed us at tab 57 approaches the strength of the claims test. In fact, in two ways. It talks about it as being obviously protective for defendants against unmeritorious or vexatious claims. You know, and it also says it's the strikeout is an additional protection, which is the sort of point you're making. There was also at least some sense, paragraph 311, for example, in some of the respondents' suggestions, that you as a claimant shouldn't be, without your consent, joined to a opt-out claim where it's not a strong claim.
Indeed.
And I'm just trying to work that through in my own mind. I mean, is that presumably because there may be other factors that would play on the mind of a claimant as to whether they want to be involved in litigation? To which the answer is, well, in which case you can opt out.
Indeed. The problem with opting out, of course, is that it suffers from the same inertia problem that drove the need for opt-out proceedings in the first place. That consultation response doesn't explain precisely what the government had in mind on the point raised by my lord, but since the issue is the vindication of the rights of those who would not otherwise find access to justice, the point is, if the case is weak or a contrivance, it's not addressing the vice which the regime was designed to create. And for that reason also the tribunal exercises its gatekeeper role and applies this safeguard.
So, I mean, I'm just trying to understand. I mean, it could be that before you join people to a claim, without their active consent, you should look for something. The strength is potentially relevant because they are going to be litigants,
Indeed.
at least in a notional way, or at least they will actually potentially benefit from it at the end, and it isn't solely answered by saying, well, they've knocked out if they don't like it.
I respectfully agree, and I wonder if my submissions along these lines were what prompted the tribunal to say what it said about buy-in. This is part, I'm sure, why the tribunal comes back to the concept of identifying the risks involved in opt-out because of the lack of buy-in. It's just a factor, but it reveals some of the risks involved and the risks involved in an opt-out case. But it's no more than a factor. And to be absolutely clear, the tribunal treated this as a factor and not a determinative consideration. It was very clear not to apply this as a presumption against opt-out. It was simply highlighting, for its own consideration, the very points which the government had in mind when it took the decisions I took you to.
Is that a convenient moment to have a break, Mr. Kennedy?
Of course, thank you.
5 minutes, then, please.
All right.
That's okay.
Which mic is live stream? Is this one?
Is it this one?
This one?
Which is the live stream mic? Which one?
This is the live stream mic.
So it's all of them are mic. Those one are called one, and that's for the transcriber. You know those. And this one are the call mic. So we are recording as well.
Okay.
So we need all of them. Those mic are very sensitive. If you move it high,
He's just coming across very quietly.
Yes.
Reading this stuff tomorrow.
Yes. Yes, we should. Yes.
Thanks for asking.
I know.
Deciding it's on
Very interesting.
Yep.
I know, I still think it's right.
That's your favourite point. I know. I'm not sorry for you. I know.
Because now it's going to be like, I want to drag out the nice times.
Somewhere there.
I'm such a coward. I'm going to go completely white. Yeah, kick me.
Logically, it's because
I suppose it was good for I'm not sliding.
Slide in, I like slide in.
Head's going.
Yeah. Right.
And it's hard to make reference, I can see that. Why that?
Yeah, that would be fine.
Just to say fine, it's fine.
Corais.
So my lords, just to wrap up that point on the proper construction of Rule 79.3, I'd like to give you just the reference to where this was addressed in the judgment. I'm not going to take you to what the judgment said. It's, as you know well by now, it's in the core bundle, tab 14, page 289, paragraphs 104 to 107. So those are my submissions on the question of construction, on the strength factor. I'll turn now, if I may, to the strength factor itself and its proper application, which is the rest of the third Evans ground and ground 6 of the Evans appeal and the first O'Higgins ground. And my short point here is that, as the tribunal has seen, court has seen, the tribunal did not just take pleading points. The tribunal held that the applications were intrinsically weak. You saw that in the judgment in the passages to which my learned friends took you. My first point here is that these are follow-on claims. And that means that the extent of the infringement is fixed in the Commission decisions upon which these claims are based. The Essex Express decision and the three-way banana split decision. The appellants are stuck with those findings. Now, they can argue about the effects of the infringements, but they cannot run a case, we say, that is inconsistent with the Commission decisions. And so I'll go first, if I may, to the Commission decisions, then I'll go to some of the PCR's evidence, and then the judgment dealing with the appellant's criticisms of it as I go. But I'll begin, if I may, with the Essex Express decision. I'm choosing that one for no particular reason. It's materially identical to the other, and so the references for the banana split one are in the skeleton. I'm not taking to that decision, just to the Essex Express decision.
Okay.
And that's in the key documents bundle, volume 1, tab 2. And because these are follow-on claims, I'm going to go quite carefully through the main bits of this decision. We say that the claims deviate very significantly from it. So page 9 first of all, and the very first recital, recital 1, the infringement is described about 5 lines down from the beginning of recital 1. The infringement consisted in an underlying understanding reached among certain individual traders, and I'll be stressing the...
Sorry, where are you?
I'm sorry, my lord, it's page 9,
Yes.
the very top of page 9, paragraph 1,
Oh, yeah,
recital
got it.
1. And I'm starting about 5 lines down in that first recital, where the infringement is described or summarised by the European Commission.
So individual traders, yes.
The single and continuous infringement consisted in an underlying understanding reached, are you with me, my lord? Reached among certain individual traders, and I'll be stressing the individual nature of that, called the participating traders, and implemented by them, by the individual traders, to exchange on multilateral private chat rooms on an extensive and recurrent basis. And they did 2 things. They exchanged, as you see here, commercially sensitive information on these chat rooms about certain of their trading activities. And then secondly, occasionally to coordinate their trading activity with respect to FX spot trading of G10 currencies. That coordination is described by the Commission as occasional. I'll come back to that. The next thing I need to show you is on page 10. I'm referring now to not to the internal numbering, but to the numbering in the bundle. And footnote 6. Footnote 6 at the bottom of page 10 makes the point that this case doesn't concern FX spot e-commerce trading activity. So the decision is addressing only voice trading. E-commerce trading, which is a very significant proportion of the total FX market and growing during the period, is excluded from the decision. The appellants say that this decision produces effects in that segment, but it is not the subject of the infringement decision. And then page 14, please, paragraph or recital 31. And at recital 31, we see the limited nature of the respondent bank's participation, because only 5 people, 5 individuals took part in this chat room. There were 4 in the chat rooms in the other decision. But here 5. Their names are given, it's confidential, in recital 31, but you can count them, and although there are 2 chat rooms, there's an overlap in members. And that membership varied over time, as you can see. Evolution and duration of Essex Express membership. First thing to note in recital 33 is that the chat room was actively used only between December 2009 and July 2012, so about 2.5 years of active use. But for almost a year of that period, it was just bilateral. There were just 2 people in it. And I'll come back to the significance of the fact that that membership waxed and waned over the course of that 2.5 year period of active use. Then go please to page 50, in paragraph 46. And we rely heavily on this in order to show the limited nature of the infringement found. Because in 46, about halfway down that paragraph, below the second hole punch, you see that the information exchange took place in accordance with a tacit underlying understanding that such information should be used to the trader's respective benefit and in order to identify occasions to coordinate their trading, these individuals in the chat rooms. And such information would be shared within the private chat rooms. And over the page at the 3, the traders would not disclose such shared information received from other chat room participants to parties outside the private chat room. There was not to be any disclosure of information to individuals, even within their own banks outside of the private chat rooms.
Is that what's meant by the word parties?
Well, that is disputed.
Can I just ask you a more general question? As you say they're stuck with this, and claims for the cat can be a combination of follow-on and standalone.
Yes.
What is the strength of the binding nature of these findings? It only binds the addressee as a matter of community law, standard community law. And I'm just trying to remind myself of the provision of the Competition Act and what it says about the extent of its binding nature on the cat and or the other parties who wish to rely upon it. Can they not supplement, add to, you have a hybrid standalone and follow-on?
Yes, they can, well, plainly, in principle, one can bring follow-on and standalone cases combined in the tribunal, even in collective proceedings. But these claims are follow-on, only follow-on. They've not suggested at any stage that they intend to amend to bring a standalone claim, in addition to the follow-on claim. And it's a clear distinction between the 2. We have in the tribunal many other cases which are a combination of, in the High Court, follow-on and standalone, but here this is just a follow-on claim.
You're, as I understand the thrust of...
And I'm also told that they're out of time now to amend to bring a standalone.
The thrust of your submission is they're, in a sense, bound by the minute particulars of the decision.
As to the extent of the infringement, yes. Not effects, but as to the extent of the infringement, they are, yes. And that's the difference between a follow-on action and a standalone action. What we see often in these cases is that claimants deliberately bring standalone actions to supplement the very limited findings because they want, for the purpose of their damages case, to get a finding that's much broader than the limited finding the Commission has taken. That's not available to these applicants because they have chosen to bring a follow-on action.
Okay. And is this dealt with in the judgment?
It is. Well, the point I'm making to you now was not in dispute before the judgment records on several occasions that this is a follow-on action.
And the judgment doesn't really deal in any detail with any of the decisions, apart from the footnote which says they haven't dealt with the later, fuller Credit Suisse case.
Yes, yes, and that is true. And the reason why I'm going into some detail on this is to help this court understand what was before.
I absolutely understand why you're going through this,
but also
if it's
also
today.
But obviously, it'd be preferable for me if the tribunal in the judgment had cross-referenced much of what it said in the judgment by reference to what I was submitting to the tribunal at the hearing.
Yes.
And what I'm showing you is what I did submit to the tribunal and why the tribunal ultimately took the decision that it did. This was put to it, and it's an important part of the intrinsic weakness of the claims, which goes to the strength factor, which is why I'm going back to this issue. Sticking then with this,
Your essential point is it's intrinsically unlikely that the infringements by 6 of these traders could have had the effect on the market that it said that they had.
that's my first point. If that was my only point, it would be said against me, well, where does that take you? That's a point for trial. The reason why the tribunal ultimately found these cases were so intrinsically weak was because of a series of points cumulatively adding to the weakness of the case, and this is just the first of them. I'm well within my time, and I'll take you to the key points to make the point. So here we have still in the Commission decision.
Just on that point, and just so I don't forget it, we saw something this morning that indicated that at least as part of the expert in the Evans, I think it's the Evans expert documentation, there was, the question was addressed, how could the activities of a limited number of dealers affect more broadly the conduct of their bank and others?
Indeed.
So it's not a point that was ignored in the material that we saw this morning.
Not at all. That point was addressed exactly as you saw, but we will say so inadequately. And it was addressed by the tribunal. The tribunal then was right to find that, having reviewed that evidence, it was intrinsically weak. We're not saying the point wasn't addressed by the applicants. It goes to the intrinsic weakness of their case. So back in the decision, next question is the value of the information. Ms. Wakefield even this morning was talking about the pervasive nature of the information. This is why I say that in analysing how weak the intrinsic weakness of their case, it is relevant when their case contradicts the decision upon which it is based. And we see the value of the information addressed in paragraph 52, recital 52, at the bottom of page 16. Pursuant to the underlying understanding, the participating traders exchanged in a recurrent and extensive fashion in these chat rooms commercially sensitive information about their trading of either immediate commercial value or commercial value lasting for a period of minutes or at most hours after it had been shared. And then we see at page 19, because that's not about bid-ask spreads. Now we're coming to the exchange of information on bid-ask spreads, and that's on recital 58 on page 19. Exchange of information on bid-ask spreads. Exchange of information on bid-ask spreads concern the instances in which the participating traders occasionally discussed existing or intended bid-ask spreads, quotes of specific currency pairs for certain trade sizes. Pausing there, obviously I rely on the Commission's finding of fact that these exchanges were only occasional.
Well, they give quite a lot of examples at footnote 33, which is said only to be examples.
Yes,
I don't know what you mean by occasionally and what, I mean, footnote 33 seems to be quite a lot of occasions.
When you come to see the PCR's own evidence, you realise that what looks like quite a lot is the tiniest drop in the ocean in the context of this market. And I'll rely on their own evidence about how huge, deep and wide and liquid this particular market is.
Yeah, okay. But I mean, you know, we're not talking about one or two instances, are we?
My lord, it may be misleading. To us, looking at this, it looks like a lot. But you have to see it, and I'll come to this, in the context of the market in which these took place. This is the most liquid. It is the largest, widest and deepest market in the world. Truly.
So you say it is a drop in the ocean?
It's the tiniest drop, because this is a market where there are millions of trades worth trillions of dollars every day. I'll come to that evidence. Recital 58, occasion then, rest of 58. The knowledge of existing, because here we see the focus of the finding, of or intended bid-ask spread quotes of specific currency pairs for certain and then look how limited this is, for certain trade sizes, where there is a specific live trade may remain useful for the other traders for a window of up to a few hours, but always depending on the market's volatility at the time, we'll come back to that, and if there was this information exchange about a specific live trade for a few hours at most, it could, but not would, enable coordination of spreads to that client, that specific client in relation to a specific live trade, that could be the outcome. And then we go to the findings of coordination, of actual coordination, which they found took place. From recital 60, you see the instances, now these are again occasional instances of coordination facilitated by exchange of information. This is not about bid-ask spreads, and it's to do with coordinating trading with a view to effecting a fix, that's the heading at a little a, and standing down, and little b. Now we move on to the analysis of spreads, whether there was how did coordination take place in relation to spreads. And for that we go to page 26. Page 26, recital 89. Traders also competed specifically on prices quoted for specified currency pairs for certain trade sizes in relation to FX spot trading. Follows that the information exchanges pursuant to the underlying understanding whereby the participating traders, those individuals that I mentioned, provided that information to one another on the level of spread quotes or communicated spread strategy for a given client in a specific situation where there was a specific live potential trade. I'm just pausing there again, see how limited the finding is. The infringement in relation to exchange, where there's a given client in a specific situation where there is a specific live potential trade. And only then may the information, may it have facilitated occasional tacit coordination between these individuals. But then this, with what consequences? Two consequences are identified in the rest of this recital 89. If that took place for the specific client in a specific live potential trade, it may have facilitated occasional tacit coordination of the spread's behaviour, thereby tightening or widening the spread quote in that specific situation. Tightening or widening, widening or tightening the spread. Both outcomes found possible by the Commission. And you've heard a lot about how inevitably spreads are widened. That's what would happen, that's what they say did happen. No one has addressed you on the fact that they're bound by Commission finding that where this took place in relation to these limited specific trades, the outcome was either tightening or widening. And there's good commercial reasons, as I'll show you, why it could be tightening and not widening. That's all I want to say about these Commission decisions.
Do we get any help in determining sort of the drop in the ocean point, if I can put it that way? I don't know whether you're going to come back to it.
I am.
Okay, so the computation of the fines that were levied goes into value to some extent.
Yes.
Is that something you're going to come back to?
I wasn't proposing to come back to what we learned from the value of or the extent of the fines. It's never been suggested that the fines tell you anything about the degree of harm that was suffered by any of the applicants. But
okay.
The fines are defined by reference to the markets concerned,
yeah,
and don't depend on any finding of actual or even potential harm. It's a different.
Now, so in terms of, it may be that the criteria of the fines are not relevant to with the proportionate effect that the trades might have had on the market as a whole.
It may be at a very high level there is a reference to the fact that this kind of conduct, because it's an object infringement, serious anti-competitive behaviour, is liable to have bad consequences, which has an impact. We'll check.
You just say we don't get anything from
you learn nothing from that. And more importantly, the applicants have not relied on that, or at least not in any major way in the millions of documents that we have before you. So before I address you, and just to reassure my lords, I want to come back to the Sterling Lads decision at the appropriate point. I've got separate submissions to make about that, but no one's suggesting that this case is based on the Sterling Lads decision. It's a follow-on case based on the two decisions that I've shown you. And before I address you on the plausibility of the PCR's claims, I need to show you some of their own evidence for 3 points. The first is about market shares and market power. The second is about the legitimate factors that inform the spreads, all the other things that made a difference to the spreads. And finally, the lack of transparency in the market. Realistically, how plausible is it that they could have monitored their behaviour even on the most basic allegation of anti-competitive behaviour, but more broadly, how to isolate the reasons for getting burned, as Madam Friend said it, in the interdealer market. So market shares first, because it's important to understand that even if all the traders and respondent banks were tacitly coordinating to widen spreads, what was their market share? And you have my primary point that the decision itself says that the information wasn't shared outside of the chat rooms. But even assuming that these 5 individuals managed to influence all the traders in their banks, and all those traders then started tacitly coordinating on the basis of what they've learned, what was the market power of these respondent banks? Because unless it's very significant, it's natural to assume that their rivals will just undercut their spreads. And remember, their spreads are necessarily uncompetitive. The finding was that these respondent banks occasionally coordinated to tighten and widen spreads. So if they widen spreads, by definition, these are uncompetitive wide spreads. One would assume their rivals, unless they're a small proportion of the market, would just step in, undercut them, and win the business. And not just win the business, but gain very precious order flow. And you'll see in the evidence how important order flow is. The more volume you get, you gain valuable information about movements in the market, which allows you to be more competitive and to win business. And I'll go, if I may, first to Professor Rhimes' evidence, his second report in the second Key Documents volume. Key Documents 2, tab 37. Second report of Professor Rhimes. It begins at page 2527. I need to go to 2565. And paragraph 74. About 7 lines down, my lords. Just above the second hole punch. The sentence that begins, in the context of the FX market. In the context of the FX market, the service offered by FX dealers is homogeneous, and the market is relatively unconcentrated. So these are the PCR's own experts saying that the service is homogeneous, the market's relatively unconcentrated. And this obviously was important for the tribunal's finding on the impact of competition within the market for the theories of harm advanced. And then this, the largest FX dealer in the market isn't any of the respondent banks. It was Deutsche Bank, whose market share ranged between 12 and 19% at all material times. The other FX dealers, including the respondent banks, having a much lower market share, single-digit percentages. He goes on to say that if you skip down about 6 lines, you see what he says was the combined market share of the respondent banks. The combined market share of between 23.9% and 48%. Now, my learner from Mr. Joel throughout his submissions referred to the 48% figure, 48%, and the court could be forgiven for thinking, well, that's a major amount, and that one could see there all kinds of consequences, umbrella effects, and so forth. But it's...
Well, he does go on to say that that's a significant, that range of percentages is significant relative to other market participants and give the cartels sufficient degree of market power to sustain tacit coordination.
Indeed, and of course that was his evidence. My point is that it was common ground that the market share varied depending on when the traders dropped in and out of these categories between 24% and 48%. And in fact, we'll see it was only 48% for about 1 year of the period. And these other market participants had smaller market shares, but we should be under no illusions about who they were. The other market participants, Goldman Sachs, Morgan Stanley, Bank of America, Merrill Lynch, these are the rivals. These are the non-respondent banks. And market share is critical for the plausibility of their theory of harm. And so I will bring you, if I may, to Ramirez. And it's critical because, not least because you heard about it so much yesterday, Mr. Ramirez's evidence in the first volume of Key Documents, tab 11. tab 11, page 575. Here, again for the PCRs, Mr. Ramirez sets out the market shares of the respondent banks over the whole of the relevant Class A periods, 2007 to 2013. And I show this to you, my lords, because having heard about the 48% market share and the market power that suggests, I know the Chancellor asked this morning, whether the other participants in the market, even the customers, had somewhere else to go. My Lord asked, with nowhere else to go. And he was not disabused of that suggestion. But we see here where else they could have gone.
Sorry, which page?
This is page 575. These are the market shares of proposed defendants. And I'm focusing only on the column on the far right-hand side.
Yeah.
And you see straight away that 48% is 2011. But Mr. Ramirez of the PCRs sets out that in 2007, 2008, 2009, for most of the period, the market shares were in the 20s or the 30s. And to state the obvious, that meant, for example, in 2007, the non-respondent banks that were allegedly subject to umbrella effects and all the other consequences that were described had 76% of the market. And of them, Deutsche Bank was by far the largest competitor.
Where's your expert evidence to suggest that this is wrong?
Well, no, we don't disagree with a word of this.
Yeah,
These
no,
market
but
shares-
you're asking us, as I understand it, you're basically asking us to draw an inference from pointing to particular tables to say, look, there are other percentages out there, and what to reach a view that the expert view expressed at the end of paragraph 74 by Professor Ryan is unsustainable, wrong, weak, or what?
So we didn't put expert evidence in.
No, you didn't. That's why I was asking the
You
question.
didn't apply to strike this out, and you didn't call any expert evidence.
No. What we did was,
That was my sort of follow-up question. I was just setting you up for it.
I know, I did see it.
And you've
Stop
got a
people
commission
reading.
decision against you.
Indeed, and so what we did, and what we did for the tribunal, rightly or wrongly, is we said to them that we don't need to put in expert evidence. On their own evidence, this case is inherently weak. We didn't apply to strike out. We invited the tribunal to look very closely at the merits. We had merits well in mind.
But that involves exactly the point that my lord's just put to you, because what that involves is inviting the tribunal to conclude, without calling any expert evidence, that this expert evidence is just rubbish, putting it bluntly.
No,
Because the experts say, I mean, what we were shown this morning how the theory of harm works, and that's all based upon the evidence, the expert evidence of these experts. We had the same thing yesterday. Well, unless you're going to say, well, the conclusions reached by these experts are unsustainable, so weak that this case ought not to go to trial. These are all trial points. These are all points to be dealt with later.
to take that in stages, if I may, because we are looking at the strength criterion in the choice between opt-in and opt-out. That's all we're concerned with. We said to the tribunal this should be certified as, if at all, as opt-in. Opt-in. And for opt-in, we rely on the fact these cases are intrinsically weak, which favours opt-in, not opt-out.
You say intrinsically weak.
Yes.
I mean, to form that judgment, it's a wonderful advocate's sleight of hand. I mean, hidden in the word intrinsic is an expert evidence evaluation, isn't it?
And indeed, and we didn't shy away. We didn't shy away from the point that was put to me by the Chancellor a moment ago. We said we can show the tribunal, even on the claimants, the class members' own expert evidence, this case is intrinsic. We didn't shy away from that. We said that look at the facts which are common ground, and then we can say based on those facts and the limitations on the claim that can be brought because of the Commission decisions, this tribunal can find even at the certification stage that these cases are intrinsically weak. And we relied...
It does involve saying that this expert case is rubbish.
Yes, and in places we...
Without having called expert evidence of your own, or cross-examine the experts.
Or given disclosure.
Or give them disclosure.
And indeed,
Or applied to strike out.
if it could be said against me, well, the points that I'm making could be cured by disclosure, or disclosure they can realistically come to, and I'll come back to that separate point, then there'll be a different debate. The points I'm making now, based on the market shares, it won't change on the basis of disclosure. All of the market shares of the banks participating in this market were in the PCR's own evidence. I'm relying on the evidence they put forward. And it's never been suggested that any of that evidence will change, any of the evidence that I'm relying on will change based on disclosure. I mean, I appreciate it's a big ask to say, based on expert evidence which has not been tested in cross-examination, I'm inviting the tribunal to find it was intrinsically weak. I appreciate how high a bar I set for myself, but that's what we did. And if you bear with me, based on the material of the PCR's own case, it was intrinsically weak. And in places we did say, with no disrespect to their professional integrity or their elevated status, that some of it was rubbish. And that's what we said. And it was a finding of fact by the tribunal, that based on what we said and what the tribunal reviewed, which is far more material than this court would be able to review, it was in places rubbish, although the tribunal phrased it more politely.
Yeah.
So coming back to the Ramirez market shares, and I'm moving on to my second. I had 3 points on the PCR's own evidence. The second was the factors that determine spreads. Even if this information is being exchanged, is it plausible that it actually made any difference to the spreads that were set in the market? And again, the PCR's evidence is in the first key documents bundle. It's Mr. Knight behind tab 9. Page 405. And paragraph 139. And there's a reference to the baseline spread. What changes the baseline?
Sorry, I just couldn't, there was some banging just as you said the number.
I'm so sorry. It's page 405 and paragraph 139.
We have the loudest dentist in history sitting behind us.
We can't hear it, but we can certainly see it. And sometimes it looks like it's going to come through your window.
Far worse than it is at the moment.
Sorry, I'm in the...
It's actually the first.
It's the same
volume.
volumes that you read, tab 9. We've only got very selected extracts.
Yeah,
Mr.
okay,
Knight.
got it.
Unfortunately,
Sorry,
we've got the
I'm
right
with you.
page.
I'm with
I
you.
hope we have the right page here. But page 405, bundle numbering, paragraph 139. And this is Mr. Knight from the PCR saying, what else moves the spread? The basic point is that how plausible is it that these occasional information exchanges made a material difference when other information was so important and it changed so rapidly? And you see I'll skip through this. These are the factors that move the baseline spread. It's just these are just examples. There are many, many more. The size of the trade, spreads narrow as the trade size increases. Market volatility is very important. The clients, and this, see how fact specific this is, the client's trading style and history of market influence. If an FX trader considers that a particular customer is well informed, it might offer a more favourable spread to retain its business. It may provide key trading information. On the other hand, an FX trader may be cautious in dealing with customers if they think they have a history of dealing with other counterparties. At the same time, thus reducing liquidity. So very granular analysis required of the particular client's trading style and history of market influence for each and every specific trade. Proximity to market moving data release. Obviously, big events can make changes over the page. The time of the day is very important for influencing spreads. Other trades being transacted at the time may create volatility. The willingness of the trader to capture the given client's business. And the tribunal will have well in mind that we're thinking here about the non-respondent banks. The factors that influence the decisions of non-respondent banks to widen their spreads, even if the Commission decision is read as just widening. These are the factual questions that the non-respondent banks, trade by trade, takes into account in determining the particular spread offered in the market. Pre-agreed contracts, spreads quoted by the competition, just a sample. And then we have Professor Rhymes' evidence about the nature of the FX market and how quickly things change. For this, I'm afraid, and I hope that this may be the only instance, I'm leaving the key documents bundle and going to the big supplemental bundle.
You can't do that, at least I can't do that, so I can't do it.
Thank you.
Justice
Justice Snowden. I shall read it out then for the transcript. It won't take long. It's a single page. It's in volume 12. Three, four, five, seven. It's the cross-examination. Actually, sorry, it's evidence given by Professor Ryan, I think, at the teaching. And you have it at page 3457. Behind tab 58 in volume 12. And here he is describing the nature of the
So
foreign.
I could do it, actually. Unfortunately, I've got to wait for the size of the document to download, so you may just want to carry on anyway.
I'm very grateful. So he's describing the foreign exchange market. He says an important aspect is that it is a global market. We'll get a copy of this rather than save your pen. We'll make sure over the lunch break copies given to you straight away in hard copy. The dealers in this market interact across the globe, either via electronic networks or the phone, and it is a really fast-paced market. So imagine you're going to squeeze 2,000 billion US dollars daily through the active trading hours, which typically is short of extended European trading hours. Then it ends up being quite intense trading. To squeeze in so much that it has to go really fast. So to put this 2,000 billion in perspective, it's about 100 times the GDP of well-developed economies with a large financial sector, for example, the United Kingdom and Switzerland. So it is huge volume. Exchange rates, they jump on news, incorporate public news, macro announcements extremely fast. Dealers control their inventories extremely fast. In FX, it could be seconds, it could be minutes. While studies from equity markets show inventory control that is a lot slower, maybe days, FX is super fast.
So can you just give me the page number again?
3457. My third point, I said I had three from PCR's evidence, is the lack of transparency. There's a lack of transparency both in the dealer to customer segment and the interdealer market. And as regards dealer to customer, we have Professor Rhymes' evidence. That's in the third volume of key documents, behind tab 58.
Can I just say, by the way, for the benefit of the transcript, the page number you gave us is the printed page number in the e-bundle, not the electronic page number, which unhelpfully doesn't match.
I'm very grateful for that.
They never do.
I remember the Supreme Court, you can get very badly told off for making that mistake. So
There used to be a very witty guide to bundles prepared by Lord Justice Sedley some, I think, 25 years ago. But there's now an update, which is the guide to electronic bundles. And I think paragraph 1 of that is that make sure that none of the references to the paper bundles match the ones to the bundles. There are a lot of others as well.
The Lord Justice Sedley one it is sadly still accurate, even though it's very old. But I'll look out for the other ones.
Make sure that the key document is not in the bundle.
And the 500
And
volumes
if it is,
are never
make sure
looked
it's
at.
unreadable.
Yes, yeah.
Okay, so you're going to show us paragraph.
So now, with some trepidation, I approach this document. So,
Tab 58.
tab 58, page 3, 4.
This is Professor Rhyme again.
Professor Rhymes' evidence, yes,
Just slightly later than the passage you just shown us.
indeed. 3459.
Yeah.
At the top of 3459, unfortunately begins what we call very opaque. He means the FX market. the market has low transparency. There are two reasons for this. First is that foreign exchange trading is over the counter, meaning it's not a centralized exchange. The second is that FX lacks much of the regulation and the supervision and disclosure requirements present in other markets. And Professor Lomas asks about transparency. If you're a large institution trying to buy lots of dollars, can you get an indication yourself? And Professor Ryan talks about price transparency. But then he goes on about how it depends on whether the customer has a relationship. His bank might, whereas customers might not have many, they may have less, they may have more information. But then he says, on page 3460, line 17, having described a very transparent market, he says FX is the kind of the opposite of this structure. So this means that the consequence is that, for example, a customer-dealer trading is primarily only observed by the two parties involved. So that's like a bilateral trade. The dealer taking part is the only one knowing this. Hence, it becomes an important information source for dealers. Now, that point cuts both ways. Obviously, the PCRs rely on it because it says that's important to get valuable information if you're doing it illicitly in a chat room. But it also demonstrates the lack of transparency more broadly. And that, again, this goes to the plausibility of the theory of harm, because even the most basic theory of harm, you heard from Ms. Wakefield, is that the infringing traders could police compliance with their understanding. Now, my Lord the Chancellor made the common sense point, well, why would they be doing the conspiracy if they weren't complying with their understanding? But it is important to the plausibility of the theory of harm, and it's accepted as one of the conditions for tacit coordination. Coordination generally, can they police compliance with the understanding? Can they see that their fellow conspirators are actually complying with the deal? And because of the lack of transparency in the customer-facing segment, it's very, very difficult to do that, unless you are specifically checking and getting proof. And there's no suggestion of that in the Commission decisions. Now, as for the inter-dealer markets, we see that at 3466. He says, Professor Ryan, there's a lot more transparency in the inter-dealer segment, at the very top of 3466. But it's still a lot less transparent than other markets. So you see it, line 20, it's more transparency in the inter-dealer segment than in the customer-dealer segment, where there is basically none, I add. But there is less than is common in markets like an equity exchange. And I'll give you a reference to similar effect. I'm not going to take up the document. It's in the big supplementary bundle, page 489. And those are the 3 points in the PCR's evidence I want to take you to. And as I said in passing, that's what we say shows how implausible is Mr. Evans' claim. Because, just to summarize, the PCRs contend that these infringing traders, these 5 individuals, or 4 in the case of the other cartel, other infringement decision, influenced other traders in their own banks, and then the PCRs rely on the respondent bank's total market share figures to suggest that all of the respondent bank's traders were tacitly coordinating. And you have my point, that is just not consistent with the Commission's finding of a closed and secret chat room. But even then, you have the point that for most of the period, the market share of the respondent bank is in the 20s or 30s. If these respondent banks offered, by definition, uncompetitively wide spreads, their rivals with 70% or 65% of the market, we say, much more plausibly step in, undercut them with their competitive prices, and gain that precious order flow, which Professor Ryan said was important to be competitive.
Why do they do it?
Why do they do it? Why do these individual traders do it?
If the obvious consequence was that they would be undercut by the bigger market out there, why on earth were they doing it?
There's no suggestion. Having acted for that question has been asked many times, my lord, by many people, and there is no answer.
Give me an answer. I was going to say.
Well, these individuals, whatever motivated them, they weren't obviously authorized by their banks. This wasn't any kind of official thought-through policy. The traders had many motivations. I can only speculate. What we've discovered.
They're rational.
Not necessarily, my lord. Not necessarily. Some of these individuals
in different cartels across all of the banks, and they presumably think it impacts upon their own, at least personal profitability.
That may well be,
Not rational.
that
Often
would be,
maximize.
that would be a rational view, and that may well have been, it's likely to have been a part or a large part of what motivated the
And it's
individual
unlikely
traders.
that they'd have, as it were, assisted their own personal profitability unless they were also assisting the profitability of the organisation.
Well, my lord, I could be corrected, but one does not, that's an obvious common sense point, but it doesn't necessarily follow. These traders, one assumes they were doing it in their own personal interest for sure, and generally that you'd expect that to redound to their
There
employers.
was evidence, wasn't there, about their bonuses? I think
There's
Lord
some, I mean,
mentioned that.
there's a few hints that, as in sterling, that the bonuses of the traders were contingent upon their profitability.
I'm
It's
not,
not much more than that, but it's not unreasonable to,
considering I'm talking about the inherent weakness and implausibility of the case, I'm not saying, it's no part, I cannot possibly say that these traders didn't benefit in some way. I'm prepared to
No, but
assume.
you're pushing it further. You're saying anybody should concede that the inevitable consequence of anti-competitive behaviour by these traders would be that they would be undercut by their opponent, by their oppo in the market. And therefore this case, as regards market effect, must inherently be very weak. And I'm just testing that by saying, if that's so blindingly obvious, surely it would have occurred to the people who were involved in this form of activity that they would be cutting their own throats.
And yet they went on doing it for 5 years,
I'm being whispered at some.
6 years.
Sorry.
I've been reminded, I'm grateful for the intervention. The core of the infringement findings, I have been taking to this, is not about bid-ask spreads at all. It's about benchmark manipulation. Manipulating the FX benchmarks, where in respect of specific trades or groups of trades, they did seek to gain profit and advantage. This bid-ask spread and information exchange, other than benchmark manipulation, is a sideshow in the Commission decisions. It was not the traders' main activity. It wasn't the main focus of their plan, if I can put it in that term. The point put to me remains valid, if I may say so respectfully, which is that why would they do it at all, even if it's a side aspect of their conduct, if it didn't help them? I can't speculate as to
Or rather, sorry, it's just to be clear, it's picking up your point. It's not why would they do it if it didn't help them. It's why wouldn't they have appreciated the point you're putting to us,
Yes.
which is that they would be destroying their own market base because everybody else would undercut them.
Because what we see in the decision is that there's the possibility of particular advantage gained at particular moments for specific live trades for a specific customer, where you've got a customer who potentially is shopping with two conspiring traders, and they both say, I've got this guy, he's asking you for a quote, I'm going to offer him this bad spread, you offer him the bad spread too, and I'll scratch your back next time. So for that specific customer, who may or may not be shopping more broadly, there may be, one can see in theory, a potential advantage. That's a million miles away from the kind of market-wide harm. Because what the PCRs say is that somehow this private chat room, defined as something secret and private, it informs all the traders in the banks, who then, as a whole, quote, by definition, uncompetitive wide spreads. And then their rival banks, who have the majority of the market, just copy them. Instead of coming in and saying, well, that's a bad price, those guys are idiots, I'm going to undercut it with something which I know to be competitive price, the price I would otherwise offer, win the business and the order flow. It's that second part that I say is inherently implausible, not the first. And the traders, there's nothing to suggest the traders were in any way concerned with the market-wide aspect. On the contrary, the Commission decision suggests they were focused only on their own individual success. And on that market-wide issue, you have my point that this is the broadest, deepest, and most liquid market in the world. That is the drop in the ocean point that I said I'd come back to. I'm relying on what Professor Rhyme said about the depth and rapidity of the market, which is why these numerous exchanges are described by the Commission's occasional are a drop in the ocean in that context. And that's before we get to adverse selection risk. but I'll go to that now. I've been describing the thrust of the Evans theory of harm. Now I'm going to adverse selection risk, which is the major part of the Higgins theory of harm. Oh, sorry, for your note, I'll come back to this and look at the judgment, but elasticity of demand is obviously very important to the point I just made about the depth and breadth of the market. And the judgment contains a finding about elasticity, paragraph 239(2). I'll go to that now, just because it was a point Lord Justice Snowden raised. Having heard the evidence that I've put to you, it's in the core bundle, tab 14, page 374. And just below the first hole punch. Having heard all the evidence that, actually, you can perhaps read, if you read the from the top of the page. Sorry, from Roman 1 on 373.
Previous page.
On the previous page, yes, because the points I've been making to you about non-respondent banks undercutting and the implausibility is what I think the tribunal was getting at least in part here in this subparagraph, Roman 1. And when you get to the second hole punch on the next page, they deal with intra-market elasticity. So just to paraphrase, based on what they were hearing from the PCR's own experts, the contracts were fungible, they were readily substitutable. The market was extremely deep and wide and liquid. And demand, they said, the tribunal, first hole punch, second page, 374, if ordinary economic theory prevails, ought to be elastic and price sensitive. As a matter of theory, intra-market elasticity ought to be very high in this market, and a constraint on price, a real one. Now they say, of course, the real world position may be very different. Maybe that what is in theory an elastic market is not switching cost relationships, or maybe the cost caused by unlawful information had the umbrella effect. They say something that the distinction between class A and class B. But having heard the evidence before, the tribunal sees that in theory, the elasticity ought to be very high. There may be other things going the other way, but then, and I think in my submission, this is what the tribunal had in mind when they addressed elasticity again in 239 sub 3 over the page, the point that Justice Snowden raised with my own friend Ms. Wakefield, that Evans pleaded elasticities of demand. The tribunal says it took everyone a long time to get to it. It's not a criticism, but despite that pleading, despite the fact that an argument is raised about elasticity of demand, which I think the tribunal has just summarised in the earlier paragraph, the difficulties that they've identified remain. The tribunal is still unconvinced in relation to the plausibility of the case. On the face of it, there should be extremely high elasticity, because that's what they were getting from the PCR's own experts, and they've not been persuaded that that's wrong, based on what has been put to them by the PCRs. Even plausibly wrong. I'll come to plausibility when I look at the judgment. But that's before we get to adverse selection risk, because adverse selection risk in my submission is even more far-fetched. I can see as a matter of ordinary common sense where there may be something in what we've been describing so far. In my submission, it's still inherently weak. But
The umbrella effect.
the umbrella effect, it's orthodox competition theory, but it doesn't work. It wasn't shown to be plausible on the basis of these facts, but more far-fetched is adverse selection risk. And to that, we need to go back to Professor Ryan. Professor Ryan's first report, first volume, tab 10. And page 508. Paragraph 187. Adverse selection arises where there is an information asymmetry in the market, where one market participant perceives, and again, all the while, my lords, bear in mind that that's what this needs to be proven in relation to non-respondent banks, where one market participant perceives that other participants may have superior information, it will seek to protect itself against being adversely selected. In the FX market, dealers take steps to protect themselves against the perceived information asymmetry. And then 188, at the very bottom only of these 4 lines, as explained in the previous paragraph, FX dealers would respond to the consequent increase in adverse selection risks by adjusting their prices in the interdealer market, with the result that bid-ask spreads would be wider. And then 193 over the page, on page 509, looking only at the last 2 lines, other FX dealers would be unaware of exactly when members of the cartels are sharing information. Instead, their awareness of adverse selection risks results from a more general concern. This is the concern the non-respondent banks are alleged to have had, that there are better informed counterparties in the market, and as a result of that, by a causal connection, they widen their spreads. But not all the information has this effect, according to Professor Ryan. If you go back to paragraph 503, so page 503, paragraph 174, he describes the categories of information that were exchanged according to the decisions. And Professor Ryan said it's B and C that are relevant for creating, this is the information that's relevant for creating adverse selection risk. I'll just give you the reference for that. This emerged from his cross-examination. It was Mr. Joel was cross-examining him. And the reference is Key Documents, Volume 3, Tab 73, pages 4916 and 4917. So it's not, my short point is, this doesn't cover all the information exchange, it's just B and C in Professor Ryan's evidence. And then we go to Professor Ryan's second report. It's in the second volume of Key Documents, tab 37.
4916.
Yes. Is that wrong?
Is that printed 4916?
Let me just quickly, yes, it's certainly, I only have printed, so it's printed 4916.
Okay.
But it's in the Key Documents.
It's not even in the e-bond, I don't think.
Oh, but anyway, it's in the key. This document is in the Key Documents.
Okay, so it's not in the e-bundle, but it is in
No,
the
it must be in the key. It must be in the e-bundle, but I haven't given you the page
Sorry,
number.
this is the second report now.
Sorry, we're still. My lord asked me a question about the
All right,
material we
okay.
just looked at.
So you gave us a transcript reference
Yes, but it was to a document that's in the Key Documents bundle,
in the hard copy.
in the hard copy. Page it's Key Documents Bundle 3. This is the one. This is not the document I'm asking you to turn to now. I just gave you the reference because I'm not planning on taking you to the detailed.
Yeah, I just want to make sure.
No, sure.
It's pointless you giving us a reference to a document which we don't have, and so I'm just checking.
No, sure.
I was looking.
So it's Key Documents 3, tab 73, page 4916. These are extracts of various bits of evidence that emerged in the trial. And 4916 is Mr. Joel's cross-examination of Professor Ryan, and I've included for your note Mr. Robertson, Mr. Robertson's re-examination. So just before the lunch break, I'll ask you to turn to Professor Ryan's second report. It's in the second volume of the Key Documents, and behind tab 37, page 2561. It's just important to understand exactly what adverse selection risk requires to be proven. And that's why I'm taking you to what the PCRs say about it. Page 2561. It's paragraph 65, and we're only looking at Roman 3 at the bottom of 2561. Adverse selection risk arises from information asymmetry, which can occur for a number of reasons, including the existence of the cartels. Mr. Ramirez's proposed methodology intends to measure the increase in adverse selection risk, which is attributable to the impact of the cartels. We're wrong to suggest that the other FX dealers need to be aware that the risk was due to cartels. Professor Rhymes says the FX dealers and the non-respondent banks don't need to know how precisely it's arisen in order to understand they've been adversely selected. Rather, they detect on an aggregate basis that they face an increased risk of trading with a better informed counterparty. They still need to isolate the loss based on perception that they're facing a better informed counterparty. And same evidence, page 2570. Page 2570, paragraphs 89 and 90. I'm going only to the bottom half of paragraph 89. Other FX dealers will be unaware of exactly when the cartelists are sharing information or trading, but their awareness of adverse selection risks will result from more general concern that there are better informed counterparties in the market. And then at the bottom of paragraph 90, last 3 lines. This is all that adverse selection risk requires as a matter of theory. Small but persistent losses to other FX dealers, the non-respondent banks, caused, and I stress that, caused by members of the cartel's information advantage would increase adverse selection risk in the inter-dealer market. And that's all I need from Professor Rhymes' evidence. Just to make sure I'm covering both PCRs, I need to take you to Professor Breeden for O'Higgins, where he gives evidence to similar effect. Right. This may be a convenient moment.
The convenient moment is 2 o'clock.
Go, Rise.